we'll flow from there. And wonderful. Wonderful. People are starting to join the webinar. It's great to have all of you here. I'll give a few technical introductory remarks in a moment, and then we'll get started. I see that there's quite some diversity in guests. We have EU officials as well as NGO people. Got some researchers, some practicing lawyers from different countries, some legal scholars.
How can you
Wonderful. I see the list of attendees, and I know many of them personally.
Okay, I can just see the name. And that too,
You
only
can,
a few of us.
exactly.
Not the audience. Attendees I can't make out.
All good. Wonderful. Well then, I suppose we can slowly get started. I wish everyone a warm welcome. My name is Alviina. I am the advocacy officer of the London Story, and I am based in Brussels. So for me, it is noon, lunchtime, and for many of the guests, it is as well. Now, some technicalities first. As you may notice, this meeting has kind of two types of audiences. There are some who have the ability to turn on their camera and some who do not. This is because initially we wanted to give everybody the option to turn on their camera, but then too many of you signed up, which means that became impossible to do. So apologies for that. We had to find a logistical solution. Thank you to all of you anyway for your interest in joining this briefing with our Supreme Court lawyers from India. We are hosting this because tomorrow is India's Republic Day. And this day honors India's constitution, which promises a secular republic which is governed by fundamental rights. The preamble pledges to secure all its citizens justice, liberty, equality, dignity, fraternity. At the same time, we are in a time in which these constitutional rights, be it freedom of speech, religious freedoms, right to life even, are reported to be under more threat than ever in India. At the same time, there are some voices in India that are arguing that the institutions, such as the judiciary and the Supreme Court, are not able to properly protect these constitutional rights. In fact, a few years ago, 4 Supreme Court judges, senior ones, in a press conference warned that things are not in order, they said, with the administration of the Supreme Court. So today, ahead of Republic Day, we are considering the role of India's Supreme Court in the protection of this very constitution. And this is extremely relevant for us here in the EU as well, because international collaboration and the EU's partnership with India relies on the rule of law and trustable, reliable institutions. To explain more about the importance for the EU, we are joined by MEP Alviina Alametsä. She is the standing rapporteur on India in the European Parliament's Foreign Affairs Committee. Unfortunately, she's not able to join us in person, but she has provided us with a video statement in advance, which I will play in a moment. Her team members are here with us, so we are very, very grateful for all the hard work that you've put in with us. Afterwards, we'll have a moderated conversation with the 3 experts from the Supreme Court of India, and I will introduce them in turn when we get there. Now, to the statement of Alviina Alametsä, I will turn that on and look forward to the conversation.
Dear speakers and participants, Greetings from the European Parliament, and thank you, London Story, for convening this meeting today to honor India's Republic Day, which is officially celebrated tomorrow. It will mark the date on which the Constitution of India came into effect 73 years ago, establishing a ground for laws that guarantee fundamental rights and civil liberties to all its citizens. I am honored to have been invited to share these opening words with you through this message. In the European Parliament, I work as the standing rapporteur for India, and I just returned from my first journey to India, where I had the honor to meet human rights activists, officials, journalists and scholars to discuss the state of India, democracy and human rights today. While the Constitution marks an important moment in the history of India, the celebrations of this day are shadowed over by urgent human rights violations that I also witnessed when traveling in India. Both EU and India have to work on these issues in our areas and acknowledge them. In India, the imprisonment of activists, attacks against minorities and repression of media are loud indicators of erosion of human rights and freedoms. Police abuse and killings, not just extremely unfortunate instances, but are part of actions to control the critical voices. To be a true democracy, India cannot fall into authoritarian rule. The people in India need protection of their constitutional rights from their government, justice system and the whole society. Defending human rights should be at the core of the EU-India partnership as well. When freedom of speech and democratic opposition are at risk within a country, the international partners of this country must cooperate and hold each other accountable as partners in democracy and human rights. I wish this also from India to the EU, as EU countries also have a lot of issues with human rights abuse, such as the rights of sexual minorities and problems in the rule of law in some countries. Because of this, I am convinced that it's important that EU and India have returned to the shared process of human rights dialogue after a long pause. We need to take this dialogue extremely seriously, as it is about human rights. The dialogue should be a vital process for cooperation to protect the human lives and the freedom of people, but that requires more concrete common goals and milestones. Both parties need to be clear what actions they are committed to in order to make progress. EU and India need to encourage and support each other in order to ensure that human rights are realized in practice. This is our duty towards our people, both in India and in Europe. When I met these human rights defenders in India, I was shocked how many of them work under very restricted circumstances in an unpredictable and risky environment. Their offices have been shut down, their funds frozen. I met respectable, hard-working NGOs that now have to work totally underground. Many international organizations have been forced to leave the country. Many activists have been detained without a due process, others silenced, and those who dare to speak out say the same thing. None of us would have been able to predict the India of today 10 years ago. The situation is deteriorating fast, yet hope remains. Activists keep fighting, organizations keep operating, and free media keeps reporting. All of this work for minorities, the poor, and those forgotten and discriminated against. The new year 2023 marks the 75th anniversary of the Universal Declaration of Human Rights. Similar developments shadow the celebration of human rights on a global scale, as they do in India on this Republic Day. This is why it is ever more important for the democracies of the world to work closely together. As the world's largest official democracy, India is at the heart of this cooperation. The democratic world needs India. We need to ensure that either EU or India pivot to the wrong side of history. My wish for this Republic Day is that India will live up to the vision on which it was built and strive to fully realize all the rights that are enshrined in its constitution. I wish you all an engaging, powerful and fruitful discussion today, and thank you for your important work.
Thank you so much to Alviina Alametsä for this statement and to her team for also continuously supporting the work in the European Parliament on India. I now, of course, turn to the main stars of the show, which are our honored guests. I will allow each of you to spend around 5 minutes to give us a general introduction of your positions, your concerns, and your thoughts on the Supreme Court of India, with whom you engage on a daily basis. We'll start with Anand Grover. Anand, thank you so much for being with us. You are a senior advocate in the Supreme Court of India. You're also the director of the Lawyers Collective, and you served as the UN Special Rapporteur on the Right to Health from 2008 to 2014. You have about 5 minutes. Please walk us through what are your general thoughts and concerns.
Thank you, Alina. Thank you, everybody. It's my pleasure to be here. I just want to focus back on what Alina started with. And I think the core values of the Indian Constitution, which the superior courts, including the Supreme Court, has to uphold, is the preamble and the values contained in that, which is, as you mentioned, justice, liberty, equality, and fraternity. And of that, all of them are under crisis, let me put it that way. And it is that we give to our people. These are the core values of our Constitution. And these are not only dear to the legal fraternity, but to all the citizens and non-citizens in India. One of the peculiar features of the Indian Constitution is that there is a fundamental right of freedom to religion, which is actually not explicitly stated in other countries. And that is one of the major issues today, which are under attack. It's not the first time that these values are under attack, but in fact, as you know, in the emergency from 75 to 77, they were under attack. And in that time, the judiciary succumbed. The situation is more egregious today. We have seen historically that when there's a strong government, there is what I would call a vulnerable judiciary. And today we live in an era of what people have called undeclared emergency. So why freedom of religion, freedom of speech are very important, and what is happening to that? I'll briefly outline what is happening to that, and in that context, take up the role of the Supreme Court. First of all, as you know, lynching of Muslims has become a major issue, where Muslims are lynched for the reason that they are Muslims on the pretext of them, say, selling beef or things like that. A large number of Muslims have been done to that with impunity, with police complicity, and no accountability. There has been undermining of pluralism and freedom of religion in India, such that, let me put it very brazenly, that Muslims, my friends, and large majority of them feel that they are second-class citizens. This is a very, very dangerous situation, and this is distinct from, say, 10 years ago. And evidence of that is available from protests arising out of the Citizenship Amendment Act and the way the protesters were dealt with by the police. The victims, in fact, have become accused and they are in jail. And with vast majority of the victims, those who are in jail, are Muslims. Apart from that, there is direct attack on the journalists, on freedom of speech. We have deaths of Gauri Lankesh. We have unequal treatment, Siddiqui Kappan. Media is being largely controlled by the government or those close to the government. And soon, independence of the media, apart from the social media, may be a thing of the past. As the opening speaker mentioned, civil society is under attack. A large number of civil society organizations have been closed down. Other statutory and constitutional authorities have lost their independence. I don't want to detail all of them. India is governed under a liberal democratic constitution where the doctrine of separation of powers is crucial for a healthy democracy. What does this mean? This means that Parliament makes the laws, the executive implements them, and the judiciary interprets the implementation. And in our country, like other written constitutionally governed countries, we have a written constitution where fundamental rights are enforced by superior courts. They have a right to strike down a law on the ground inter alia on violation of fundamental rights. Now, all this requires an independent judiciary. Now, there has been increasing politicization of the judiciary. Now, this is not India alone. It has happened the world over. Please see the decision of the United States Supreme Court in the Dobbs or the abortion case. I've argued elsewhere and I've given a speech on this. The reasoning is completely flawed legally. But the decision to overturn Roe versus Wade was made by judges who are known conservatives, despite the fact that they actually said in the Senate that they agreed with it. In this context, India is not an exception. When you have a very strong government with a particular political ideology, the judiciary actually becomes vulnerable to attack, and the independence of judiciary is under attack. Now, a person who becomes a judge, because we are drawing judges from the general public, the legal fraternity, they have political views. If I were to become a judge, I would also have to change my way of functioning. The person who becomes a judge, he, she, or the transgender, we don't have transgenders right now, we may have a gay judge soon, has to not decide on the basis of political ideologies, but on the basis of the rule of law. But if we have, like we've had, praise of a political party or a political person, how can we expect about an independent judiciary? We've had a particularly bad period recently, and this is ironically immediately after the judges held a conference about the threat to independence of the judiciary. And that was about allocation of matters, rostering, and the Chief Justice's role. So if you want, I'll stop here. I can go back into these issues. Cases have not been taken up. Cases have been decided not in accordance with law, etc. And latest about the appointment of judges, which I think are crucial issues. We can discuss them in detail later. I only want to say this is a great concern. We are actually undergoing a period of crisis. Fortunately, I would say the collegium has taken hold of the situation in the recent past. We live on hope, but not only on hope. As the legal fraternity, we have to be watchdogs, not only with the judiciary, but also for citizens. If we stop functioning as watchdogs, we can't hope the judiciary will be independent. And it'll be a constant battle. It's not only a time-sensitive battle, it'll go on for a long time. Thank you.
Thank you, Anand, for laying out your concerns here. You really covered a broad range, and we'll certainly go into many of these again in the conversation. I'd like to pass on to Prashant Bhushan, our other esteemed panelist today with us. Prashant, you are affiliated with many organizations, and you've done fascinating work as well. You are a public interest lawyer. You have done work with the Center for Public Interest Litigation, the People Unit for Civil Liberties, Transparency International, the Working Committee on the Campaign for Judicial Accountability, Judicial Reforms, many hats that you hold. What have these taught you, and what has your experience shown you regarding the Supreme Court and its role in upholding the Constitution? Same thing with you, just a brief overview, touch upon some topics that we can go into depth a bit more on in the rest of the conversation.
So thank you, Alina. As Anand pointed out, and as the Human Rights Rapporteur pointed out, India is certainly facing the most serious threat to its republic since its founding. I would say that the situation today is even worse than it was during the emergency of 1975, when fundamental rights had been suspended and press censorship had been imposed. Because what we are seeing today is a systematic assault on all fundamental rights, on our democracy itself, on most of the institutions which have been created to protect democracy, particularly on the judiciary, on the media, on the election commission, etc. In such circumstances, the Supreme Court in particular, and the high courts in general, that is the superior judiciary, are expected to play a very important role in, in protecting fundamental rights, protecting other institutions, and protecting democracy. Unfortunately, in the recent past, at least in the last 6-7 years, soon after the Modi government came to power, we have found that the Supreme Court, by and large, has not lived up to its expected role, has not been able to protect rights and institutions. And if you look at, that's clear from the manner in which they have dealt with a lot of the major cases which came to the Supreme Court, which were politically sensitive. For example, the Ayodhya case, where the mosque which was torn down, that land was given to the same people who had been accused of tearing it down in a totally illegal manner by the Supreme Court. It was also evident from the manner in which the Supreme Court dealt with several corruption cases involving the Prime Minister himself, particularly the Birla Sahara case, or what is known as the Birla Sahara case, or the Rafale aircraft deal case. Then it was also very clear in the kind of role that they played in the murder, in the case involving investigation into the murder or alleged murder of a judge who was trying our current Home Minister for murder and conspiracy to murder. In all these cases, the Supreme Court, or in most of these cases, the Supreme Court violated the principles of natural justice by accepting unsigned notes given to the Supreme Court by the government in a sealed cover, and decided these cases on the basis of those notes. We have also seen that in many cases, the challenges which have been made in the Supreme Court to, for example, the Citizenship Amendment Act, to the amendments that were made around Kashmir, have not been taken up, and those cases have been languishing in the courts. Also, there have been several habeas corpus petitions which have also not been taken up for a long, long time. So, but recently, with the new Chief Justice and the previous Chief Justice who came in for a very short while, for 2.5 months, Chief Justice Lalit and the present Chief Justice, things have certainly improved. And the Supreme Court is now playing a somewhat better role in protecting rights and liberties, etc. However, the reason why this has been happening, there is a several-fold reason, but the main reason was underlined by the 4 judges in their press conference, that unfortunately the government was able to get some kind of influence. This government uses all agencies, investigative agencies, to find something, some vulnerability in the judges, particularly the Chief Justice of India, and if they are able to get that, they exploit that vulnerability in order to subvert the independence of the Chief Justice, and thereafter they can subvert the independence of a large part of the judiciary because of the important role played by the Chief Justice in allocation of cases, etc. So I'll stop here, and we can take up some of these issues in the questions. Thank you.
Thank you, Prashant. I find it very disheartening that both you and Anand Grover have said that the situation is not just similar to the 1970s emergency, but potentially even worse. This is definitely something that we can revisit throughout the hour. Next, I invite Shahrukh Alam to give her thoughts and her points that she'd like to discuss more. Shahrukh, we're so happy to have you with us today. You are a person that's also worn many hats. You've been a social activist, you've been a policymaker, you've been a field researcher, a professor, and now you are an independent practitioner at the Supreme Court. And your work is focused on constitutionality and criminal law, and the past experience that you bring to it means that you also have some strong views and have published quite eloquently. So very happy to have you on board, and I'm very happy to hear your thoughts as well. Please take the floor.
Thank you, Alina. You're very kind. I have two propositions to make. And the first is that increasingly, our courts are adjudicating cases through the prism of national security and law and order and national interest, and not on their own terms. And our courts are not giving enough thought to what constitutes national security, or indeed what constitutes our nation, and therefore national interest. We've always been a very, very stratified society and polity. And some people find themselves at the center of things, and there are people who've always been on the margins in terms of caste, in terms of class, in terms of region. And then there are people who've always been considered outsiders to the nation, the Muslims in particular, also the indigenous people. Also in terms of sexuality, there are people who are considered outside our culture and our national traditions. So when we're talking of national interest, and increasingly when we're judging cases through that prism, our courts have not been conscious of the fact that a whole lot of people remain outside of that particular parameter. And the oddest example of this, of sort of bringing in national security and law and order, was on display in the hijab case, where the state of Karnataka used this as an argument to sort of argue against any kind of temporary relief to the girl students. So even while the hijab case was being adjudicated in the Karnataka High Court, during the pendency, the students moved an application saying, while the case is being heard, on balance of interest, allow us to go and attend our classes and write our exams, because on balance, we have much more to lose. And the state brought in the plea that no, it will cause law and order issues, it will cause law and order problems. Thus basically putting forth the idea that the heckler's veto has precedence over people's rights. And the court accepted that argument. The court said, yes, law and order is primary, and you may not attend class and you may not write your exams if you insist on wearing a hijab. So that is the prism I'm talking about. The second proposition is that there has been a normative shift in the language of the law. And once language changes, there's always a shift in the logic of the law and how you sort of think through things. And one very obvious way is to frame this in terms of bias, that the judges are biased. But I think there's more to analyze, there's more to inquire if we just think about how insidious language is. And once language is changing, once the language of law is changing, it's so insidious that you just start to think differently about things without being overtly biased. And I'll give you an example. You know, when the Citizenship Amendment Acts were brought in, what they were going to do was to reconfigure citizenship status. So a lot of people were scared that all this while they had been secure in their citizenship as Indians, and that was going to be suddenly reconfigured. So there were large-scale protests against that. And now a lot of those people who were protesting, as Anand was mentioning, find themselves in jail. So there was an infamous criminal complaint. It's called the FIR 59 of 2020. Basically, it was a criminal complaint against these protesters. And on the basis of this complaint, these people find themselves in jail. It's always been my argument that the language of that criminal complaint, it did exactly what the Citizenship Amendment Act was going to do. It reconfigured citizenship. Suddenly, it made it impossible for certain communities, particularly Muslims, to dissent, to participate in public dissent, even when it was completely nonviolent. It made it unacceptable. So it redefined the rules of citizenship for Muslims. And I just want to take a minute and just read out what the criminal complaint said and how it reconfigured citizenship. It said speeches were given that encouraged people to protest in the streets, that aimed to internationally further the propaganda that minorities were being oppressed in India. Now, even if it was political propaganda, it's still not an offense. But suddenly this language, which has now entered the logic of our courts, has put people in jail. And I'll read just one more sentence, which is what the court had to say about this criminal complaint. The court says, the accused inconvenienced commuters and embarrassed the government. They provided to Muslims an articulation of their grievances and created a Muslim critical mass. So this language now that criminalizes political articulations and political mobilization has been made into an offense. I'll stop there. I'll come back to the questions and answers. Thank you.
Thank you so much, Shahrukh, for also your clear two issues that you wanted to flag. We will return to both of them for sure. But let's take a big step back. And I'd like to discuss a bit with Anand, and then perhaps the other of you two can jump in on this. India has been repeatedly praised internationally for its judicial activism. I mean, India has a common law system. It allows for rules of interpretation, allow for judges to be creative, and even the Supreme Court is empowered to take up cases without there having been a formal petition or complaint. And this seems fantastic. Now, my question is whether the Supreme Court has been doing that. Has it been judicially activist, and which cases has it chosen to take up and which hasn't it? Anand, can you give us some insights there?
Well, first of all, I would beg to differ with you. It is only superficially the Supreme Court is known to be activist, in the sense that it has assumed jurisdiction on what is known as public interest litigation. Originally, it was a device created by the Supreme Court to help poor people, who didn't have access to justice. Over a period of time, it has become a political instrument, and it is used sometimes for the betterment to, Prashant, and sometimes we actually use that to change the political power relationships, but largely it has been now used by political parties to settle scores in the Supreme Court. So I don't think it's an instrument which should be praised without any criticism. That's one. Secondly, I teach at Georgetown. One of the major problems I find in PIL's judgments, apart from the issue that Prashant actually alluded to about notes in a sealed envelope, which is totally illegal anyway. But anyway, that was a period of time, in my opinion, time after the judges' conference, and now till Justice Lalit became the Chief Justice, where we had a very difficult period for various reasons. And I hope we have overcome that, but there are structural problems which remain. There are very few reasoned judgments in PIL. PILs are not reasoned judgments. They're not easily applicable around the world. So when we teach, for example, health law, you'll find very few judgments which are proper reasons. So though it is known as an activist court, the kernel of reasoning is absent. But I think we are more interested in the situation as it is today, which is not amenable to purely public interest litigation. It is the fundamental issue where the freedom of speech and plurality in Indian society. And India is one of the few countries in the world where religion, practicing, professing, etc., is a fundamental right, and equality of religion is a very important part of fraternity, which is in the preamble. That is being eroded. That is the main issue. Apart from the way, as Shahrukh has mentioned, the way language is twisted. For example, sedition is now not what used to be. If you say something against, and that is evident from the letter written by the government to the collegium, why a particular person should not be on the bench, because he has written a letter, and that is how it is being configured. They consider any criticism, unfortunately, as not dissent, but not acceptable in a democratic society. And that is the actual manifestation of the crisis that we are in today. So we have to reclaim that space. And I'm very happy, like Prashant, that Justice Lalit actually did a bit of course correction, but we cannot rest our laurels. In my opinion, because we are a maturing democracy, I like to use that phrase. We're not fully mature democracy. Whether we actually achieve that or not is an open-ended question. And that's why it's a crisis. That's why we have to fight. And it is our duty to make sure that we support the judiciary in their issue with the government, so that the independence of the judiciary remains. And it is upon the bar associations to make their stand very clear. Unfortunately, the bar associations are very quiet on these issues, and that's a tragedy. If the bar is not strong, how can we expect the judiciary to be strong? That's one level of protection for the judiciary. If the bar is strong, then judiciary can expect support from the bar. And I find that that's also a lacune in our society. Apart from the fact, and that's the last point I want to make, I think the cooperation between the European Union and other parts of the world. I mean, I have been in Kenya. I was born there. I've done 2 amicus briefs in Kenya, argued in the Brazilian Supreme Court and in the Australian High Court. One of the things that is important is that there should be exchange of judiciaries. This happens in South Asia and the National Judicial Academy. So judges supporting other judges in other countries is very important in liberally governed, constitutionally governed democratic countries. That's where we have to have cooperation. Because judges must feel that they are supported by other judges. They must feel that the bar supports them. And both these things are lacking at the moment. India actually needs, as does the US. Let me be very clear. The US is going through the same problem. It's a politicized judiciary. The Dobbs decision is not legally sound decision, the abortion decision. So we need to actually cooperate and tell them that the decision is based on wrong legal reasoning. And we need to interact to get out of the framework of mind that they're in. Apart from the language issue, which I think Shahrukh did very well to allude to. Thank you.
Fascinating. Also, thank you for putting forward a very concrete proposal, which definitely we can explore further. Prashant, what about you? What do you think are some of the cases that the Supreme Court should have been dealing with, but isn't? I've read that, for instance, it has left several cases pending for several years, even though they are of fundamental importance for constitutional rights. Which ones has it not picked up that you believe it should, and why?
There are 2 very important and obvious cases. One relating to the challenge to the Citizenship Amendment Act, which is discriminatory against Muslims because it excludes the Muslim community from being granted citizenship because of religious persecution or any other ethnic persecution, etc. The other case is the challenge to the changes that have been made, the amendments to Article 370 and changing the structure of Kashmir from a state into 3 union territories. Those challenges have been pending for a very long time and they have not been taken up by the Supreme Court. Some other cases that the Supreme Court ought to have taken up are, for example, this new thing that is developed in India, which is called bulldozer justice, where various governments, especially BJP governments, think that it is okay to bulldoze the houses of people who are accused of any crime. Now, their crime has not been proved. They have not even been formally charged for that crime, but just because there is somebody or the government who accuses them of committing some crime, therefore their houses can be bulldozed without any adjudication by any court or without any provision of any law. And unfortunately, this is now going on a very large scale in India, where the rule of law is being demolished And this is a matter on which the Supreme Court ought to have intervened suo motu and said that this is totally unacceptable. And if any government or any authority or any police does this, then the people will be made accountable. So these are some of the cases, but there are many more that they could have taken up. Unfortunately, some of the cases that they are taking up these days as activism are exactly the opposite of what they should have been taking up. For example, they have recently taken up a case filed by one of these BJP members who says that the Supreme Court should come down on religious conversions. This is the same kind of rhetoric that this BJP government, the right-wing, what I call Hindu majoritarian fascist government spouts, that there is large-scale forced conversions being going on. So this is another issue which the Supreme Court ought not to have taken up as a kind of public interest litigation, but it has taken it up.
It's fascinating that you mention as well the demolitions. Thank you, Prashant. What we've been discussing in the European Union bubble, I suppose, is the fact that this creates a lot of uncertainty. If houses are randomly demolished, and even though the Supreme Court did intervene, as I understand, once and said, please stop this, it still continued. Do you think that if there is a, for instance, foreign investor who wants to partner with a certain company, and that company is then accused of being having built on illegal land, do you think that the judiciary is able to give this legal certainty? Can it protect, I suppose, the property rights of people who would come in from abroad? And this is through, for instance, a trade lens here, but applies more broadly with the rule of law.
So foreign investors who come in India are often sort of faced with some crooked crony capitalists of India. And if they have a dispute with a crooked crony capitalist of India who enjoys the protection and the patronage of the government, then the foreign investors usually have a very, very tough time, both in terms of how governmental authorities deal with them and also in terms of how the courts deal with them. Because the courts, we have seen, often act, if the government is siding with a particular crony capitalist here, then the foreign investor or the foreign company usually has very little chance, even through the court system in India. Unfortunately, so therefore, a lot of foreign investors are discouraged from investing in India because of what they see is the uncertainty and, of course, the delays of the Indian judicial system, and often the lack of integrity also of the Indian judicial system.
All right, thanks for that little insight into our detour on investment. Now, Anand and Prashant, you both in your initial intervention, you mentioned the importance of who the current Chief Justice is. You also highlighted that there is a bit of hope now with the new Chief Justice, and touched on that. And more broadly, I saw a couple of statistics regarding who the judges are that sit on the Supreme Court. Apparently, reportedly, only 5% of the Indian population are Brahmin, but 40% of judges in the Supreme Court are. And now Brahmin, for those who don't know, is the most dominant caste or the upper caste in the caste system. And the statistic I found also said that 93% of Supreme Court judges are men and only 7% women. Shahrukh, how does this play out in practice? What does that mean for the diversity and the ultimate outcome of how judgments are play out, given that there is this lack of diversity in the Supreme Court?
I was talking about the idea of the nation earlier. When you're talking of national interest, and when you're adjudicating cases on the basis of what constitutes national interest, but you only know what is in the center of the idea of the nation, you are not familiar with those who are on the margins, then you adjudicate in a particular way. I do think that judicial reasoning is only a part of the process of adjudication. There's a lot of subjective assessment. And in my work, I see that in how judges respond to hate speech, for instance, or insightful speech. When there is familiarity with those who are making that hateful speech, there is a lot more indulgence shown because there's no fear, there's no suspicion. You know those types of people. So a lot of times criminal complaints don't get registered because the police and the lower judiciary, and sometimes even the higher judiciary, are more indulgent. They don't take that seriously. Whereas on the other hand, if it's somebody who's not so familiar, when that person is making similar speeches, there is a fear, there's a sense of you're unnerved. And that again is very relevant in the idea of the terrorist or terrorism. So if we had more diversity, I think some of these notions where subjective assessments do creep in would be more neutral. And I also just want to add one other thing to this. You were talking about judicial activism earlier. Law has always prided itself on its neutrality. We were taught in law school when we were critiquing law that if the law says that it's illegal to sleep on a public bench in a park, then it applies equally to the senior lawyer and to his driver. But therefore then, the courts, when they are being judicially active, they have no sense of social or political power. They treat the most marginalized person who comes to court in a public interest litigation equally to those who are very powerful politically and socially. And that does not work out very well in terms of the power dynamic.
Thanks, Shahrukh. Now, the question that comes up then, there is this lack of diversity within the judges. And this plays out in the adverse ways that you have described, specifically using the lens of nationhood that you just mentioned. How do judges even get appointed to the Supreme Court? What are the methods there? And since all of you have said there is quite a lack of independence and that there's some judgments that are even influenced by definitely non-legal considerations, is there anything we should reform about how judges are appointed to improve this? Prashant, maybe you want to start on this and then we can build from there.
Yeah, so see, now judges are finally selected by a collegium of senior judges of the Supreme Court. Of course, if they are appointments to the high courts, then the recommendations come from the collegium of senior judges of the high court also, and it goes through the state government and then goes to the central government, etc. And once the collegium makes its recommendations, it goes to the government once more, and the government can return it with reasons once. But thereafter, if the collegium unanimously reiterates that recommendation, they are supposed to be appointed. Now, the governments have been wanting to have a direct say in the appointments by way of having its own members in the collegium or in the selection committee. And they attempted that through a National Judicial Commission Act, which was struck down by the Supreme Court on the basis that this violates the basic structure of the Constitution, which is independence of the judiciary. But that was absolutely right, because the government certainly should, being a major player in all these cases or all the important cases which come to the courts, should not have a direct say in the appointments. But unfortunately, even in the present system of selection through the collegium, there are problems. There is lack of transparency. They have not even laid down a proper criteria on the basis of which they would select and how they would judge people on those criteria, etc. Nothing has been laid out. And therefore, there is considerable amount of nepotism also, which comes across in the whole system of selection through the collegium. However, it is still better, at least it produces relatively more independent judges than was the case when the government used to appoint judges, or even when government gets a direct say in the system of appointments. So we certainly need, actually this whole business of selecting judges is a full-time job. It needs a full-time body rather than an ex officio body of sitting judges or the law minister, etc. And that body must be completely independent of at least the government. And that body should go about its job methodically by laying down a criteria and with some degree of transparency. So these are some of the reforms that need to be done in the system of selecting judges. But the present debate in India is whether the government should have a say. And there I feel that the government certainly should not be allowed to come in, because as it is, they are unduly influencing the selection of judges by not even appointing judges, or rather sitting on recommendations made by the collegium, and not appointing those who are even unanimously reiterated by the collegium. They are brazenly defying the law and thereby stalling appointment of independent judges and trying to bargain with the collegium to get their own people appointed.
Thank you for those proposals. It's surprising to say that, or it's surprising to hear that you said that there are no proper criteria laid out for the appointment. Shahrukh, if you had a say in what these criteria would be, what would you add?
I think somebody who had a sense of political social power, somebody who was more well-versed in literature, and somebody who's I don't think it's enough to just be very good at black letter law. So somebody I would encourage diversity. I would try and find ways to bring in more people from the margins into the center.
What about you, Anand? What thoughts do you have on the appointment process?
Nishant is right. The way though the government legally and constitutionally has no say in the name of judges being picked for appointment to the superior judiciary, they do that by actually vetoing, by not appointing. So the bargain goes on, which allows the government to have a say effectively. Now, your question was about diversity. You know, if you want diversity, you have to actually rear the legal fraternity. That's lawyers from the time when they become students and then lawyers. And if you say have very few women or transgender people or gay or Muslims, etc., you won't have many people to pick from, you know. So what is happening is at the level of lawyers, there are very few diverse communities in the legal fraternity. So then you can say, well, we don't have the people. But in terms of women, there's been an effort to make sure that women are coming in, even in terms of senior counsel. And they deserve it, a lot of them. But not all judges deserve to be judges in the Supreme Court or High Court. You know, you can, this is a major problem. You know, what is happening in the courts, higher judiciary now is people have never practiced a particular branch of law or deciding the law. Especially in criminal law, I found that a lot of the judges have no idea about trials or evidence taking, and they're deciding seminal issues on that. So, you know, the criteria should be, of course, competence. Whether it actually comes in or not, we don't know, because there's no criteria laid down. Secondly, diversity on the basis of competence and encouraging people in terms of, especially in terms of caste, gender, other diversities and minorities. It's very important, because if you do not have that, the faith of those people will not be reposed in that highest institution. And we must remember that the judiciary is the last bastion of protecting fundamental rights. If this institution goes, the superior judiciary goes, nothing remains. Then it's free for all. I don't think even the very strong proponents of the government would like to see that completely. They may imagine that, but they don't know the answer. They don't know the consequence of that kind of thing. So I think there has to be a dialogue properly to make sure that you have competent persons from diverse groups and interests within the judiciary from the lowest level, even in law schools, encourage people from the Dalit community. I find that in my office, we consciously encourage persons from different communities, genders to join our office. That's not true in most of the offices. The first thing is where was your father working? Was he a lawyer or not? Was he a judge or not? And then if you're none of those, you don't get a job. That's what it is. So I don't blame the judiciary. I think we are at fault. And I made a conscious effort to make sure people who are not within the legal community echelons, they get jobs in our office. And I found some brilliant people who are very good. And now they're actually making a good job of being lawyers, but they need to be encouraged. They need to be trained. They need to be, the legal skills have to be taught. Litigation skills have to be taught. There's a lot of training. And I'm fortunate that I teach also, so I can do that. But I've not seen that within the bar. The bar associations don't do anything. The Bar Association has set up a law school in Goa. I don't know how that is going to fare. But there's a lot of work that has to be done by lawyers also and judges. So if we feed into the system people who are good, who are bright, who are competent, who are looking for challenges, and India has a lot of challenges, then we can hope of having a diverse judiciary which is competent. If they're not competent people, a matter which would take 1 minute will take 1 day. That's what's happening today. Thank you.
So we do have a bit of a glimmer of hope now from your side of what needs to happen for things to get better. But of course, the thing that has been recurring in today's conversation is the parallels to the emergency era. And one person has asked in the Q&A about the emergency era as well. Thank you for that question. Anand, staying on you, perhaps this is right up your alley. The question was that during the emergency era, there were forced sterilizations reportedly in India. And the asker of this question wonders whether the current situation related to sexual and reproductive health in India is in any way potentially might end up in a similar situation. Perhaps this is only one example of many, but what are the fears that you have if things don't get better, but really turn more towards emergency era rule of law?
I don't believe in looking at things won't get better. It's up to us to make sure they're better. If you don't have the attitude, you will give up before you start. So first of all, I think in terms of reproductive health and forced sterilizations, they occurred in India even in the non-emergency period. So I don't think that's linked to emergency or suspension of fundamental rights. But there are more egregious violations in terms of freedom of speech, in terms of plurality of religion, which is the agenda of the ruling party. They want to make India into a Hindu nation. That's the professed claim. What does that exactly mean? Does it mean dismantling the constitution? We don't know exactly, but the indications are towards that. Those are more egregious violations which we have to be concerned about. And in that, the judiciary has to play a very important part. I think now the judiciary is also aware that things are not the same as they were 2 years ago or 1 year ago. I have hope, and it's up to us to make it clear to the judges that we are with them on this issue. And we will hope that they will do something. But we cannot leave it only on hope. We must be active too. Thank you.
Thank you, Anand. And since we've spoken a lot about broadly, more specifically, the judiciary, perhaps can we briefly, as the last question, also respond to one of the questions in the Q&A about the legal profession more broadly? Have there been any steps by the Indian government to strengthen the profession? Here, for instance, we might talk about legal aid, trial support, defense support, and so on and so forth. Prashant, do you want to go into this?
Well, the legal aid services are essentially run by the high courts and the Supreme Court themselves. So far as the government is concerned, the government has not neither taken any steps to strengthen the lawyer community, nor taken any steps to strengthen the judiciary. In fact, there is a law called the Gram Nyayalaya Act, which was brought in more than 10 years ago to set up courts at a lower level than where they are presently, and they were supposed to be more informal courts. to settle disputes, small disputes among people, where people would not even need lawyers to approach those courts, because that's one serious problem that common people in India have, that they don't have the financial resources to engage lawyers for their problems. So unfortunately, even that law has not been effectuated in India, has not been implemented so far, with the result that even those courts are not there. So far as the government is concerned, especially this government, it would be very happy to sort of allow the judicial system to just wither away, and of course lawyers with them as well. So this government has certainly not, nor have previous governments taken any steps to either strengthen the legal community or the judiciary really.
Can I just intervene on that point? Well, the question I've seen on the Q&A, it's about providing critical legal aid at the time of, say, arrest and trial. I'm familiar with the English duty solicitor scheme. There's nothing like that in India. There are private bodies, and there's, for example, the National Law University Death Penalty Project, which is very good. They actually give legal aid to people who are on death row. So I have worked with them quite a lot. So they have a very good system where they can contact persons on death row. They provide legal services through lawyers in the High Courts and the Supreme Court, as also providing other legal services in terms of statements, looking at the family history, etc. That is working very well. That is what is needed to be encouraged. But that's not happening. The government scheme, the legal aid scheme, the National Legal Aid Services Authority, unfortunately, is able to do things where the group is active on the ground. It all depends on who's active on the ground. There's no uniform system of quality and competence. So that needs to be worked upon. I think that also can be used. I've had good experience with some of the legal services authority organizations in doing work on different genders, transgenders, etc. So that's been quite good. But not all of them are as competent or as good. But they need to, there's a lot of money there. There's a lot of work that can be done there. But unfortunately, it's being done through the judges. And I don't think they have the time. You need a professional authority to run that program. But that's not forthcoming right now.
All right.
I
That
also
is
just add, I'm very sorry, Alviina. I just wanted to add, Anand had spoken about diversity in the bar earlier also, but I've seen over the last 3 or 4 years that there are many young Muslim and Dalit lawyers who are very active in terms of providing support at the time of arrests, particularly during protests, etc. So that has happened a bit, that kind of legal services. But on the other hand, there's also a very organized drive by the ruling party, the BJP, to encourage lawyers to actually become members of the party. And they're offered a lot of sort of benefits in turn. So there's a drive towards that also. Many lawyers are now card-carrying members of the ruling party. And there are others who are sort of also providing legal services to the most marginalized.
Thank you so much to all three of you. We have now reached the end of our session here, since this was scheduled to be within the lunch break, and the lunch break is over. We have gone really into the nitty-gritty here while trying to stay as understandable to people without a legal background as possible. We've looked at the appointment process of the Supreme Court. We've looked more broadly at trends in the judiciary. We've looked at discourse. We have looked at the independence, and therefore concluded that there are some serious concerns, if I hear you correctly, about the judiciary and the Supreme Court in India, which echoes also what former judges have said. And you have also said that if action is not taken immediately, which is absolutely within our power to be taken, but if that action is not taken immediately, then things may get much worse. This is a big concern also to the EU, since India's strong theoretical commitment to the rule of law and fundamental values makes India a potential like-minded partner of the EU. And therefore, especially Anand came with some wonderful concrete proposals for the EU and India to potentially engage on a judge exchange or to support with a duty solicitor system, etc. If you have any resources that you would like to share with the audience after this, please just send them to me and I will pass them on. And dear audience, I will be sending key points from today's discussion to you via email in a while so that you have all the information together. We will continue to work on this. We were founded as the London Story because we want to defend India's constitution and believe that it is a wonderful document. And therefore we'll also be celebrating Republic Day tomorrow and wish all of you a wonderful Republic Day as well. Have a fantastic afternoon until then, and till the next briefing, which will be in roughly 1 month, information will follow. Goodbye.
Thank you, Alina.
Thank you very much. Thanks.